see here. So we talked about the 5 important documents. Those are them, and then we're going to go into detail in all of those. One of the points you need to walk away with today is understanding the difference between a trustee and a beneficiary. I'm going to add to this understanding an executor, because in Texas, in a will, what the person is called is an executor. Has anybody here ever served as an executor? Okay, these women in the back and have right here. And if you want to share anything or if you have any questions, no? Okay. I've also served as an executor before, and doing that firsthand, I learned a lot. It's a lot of work. I bet some of you have been named by other family members as executor. A lot of times, parents choose their adult children. What that means is that you are in charge of the financial decisions. You're in charge of looking at the will and making sure everything in the will is done according to plan. So if you are the executor in your father's will, for example, upon his passing, you would take his will and you would make sure that all of the gifts he wrote in his will were given to the proper person. Same with a trustee. A trustee is going to hold the property in trust and not be the beneficiary of the property, but be in charge of protecting the property according to the trust documents, distributing the property to the right person at the appropriate time. You know, the importance of being prepared for life changes, I can't really emphasize that enough. That's going to come into play when any life changes happen. So if you have adopted a child, if you birth a child, if you get married, get divorced, lots of reasons why you need to relook at your estate planning. I'll tell you, a couple of months ago, maybe 2 months ago, I just finished with a very contested case that was where this individual did not look at his estate planning documents after he was divorced. So this man was making, moderate income and had a significant 401k account because throughout the course of his life, he had been investing a certain percentage of his salary into it. I don't even think he realized how much he had built up into his retirement plan. But he had divorced several years ago, had one daughter, wanted the daughter to have everything upon his life. He was single, and he worked overseas. He did oil rig work, and so he even texted her before he left for overseas, if something happens to me, I want you to have everything, I love you. Well, the man goes to work and ends up dying on the job, and all of his money was given to his ex-wife because federal law governs retirement accounts, governs 401k. He had never changed the beneficiary, so the daughter came to me with this problem, and fortunately for her, we got positive resolution for the daughter, but it was a very, very tough battle, very expensive to do. So if you can, anytime you have a life change, make sure that you have everything in writing. Your family members won't have to suffer like my client did when she came to me, and the holding company had given all of the money to the ex-wife, who obviously had spent some of it by the time she found out, there was possible recourse for her. Let's see here. So accidents, illness, natural disaster. Death isn't the only reason you need to do estate planning, so also illness is important. I know that we've got a lot of adult children who come in who have elderly parents who are hospitalized, and the nurses or the doctors just will not give those adult children information without a medical power of attorney on file. And so I've got a very well-known nurse that walked into my office and said, I can't believe after all these years taking care of my mother, they won't even let me make a doctor's appointment for her because now they're enforcing the Medical Privacy Act and, HIPAA laws and everything else that goes along with that. And so we've had to work around some situations for people that have elderly parents that need documents, executed right away. I've had to go to the hospital, go to hospice for people, go to different things to help them get things lined out when they are presented with difficulty because they don't have those powers of attorney fully executed, and the staff is just doing their job and is saying, you know what, we can't help you because you do not have power of attorney. So the power of attorney, again, is effective only during life, and it allows whoever you've named to speak on your behalf. So one question is, where are you in the process of getting your affairs in order? Do you have a will in place? Do you have powers of attorney? Do you have a letter of instruction? Do you have your financial documents centralized so that people can understand and know what accounts you have, what assets you have, what are going to pass pursuant to contract, what are going to pass pursuant to your will? If you don't have any of those, or if you do have them and you've had a life change, maybe you have even changed jobs, and so you need to simply contact the holders of your policies, your insurance company, your retirement account, whoever you're getting benefits through, and just make sure you have the right person named on those documents. I really want to emphasize the importance of making sure you have the right beneficiary named on your contract. The experience I explained to you where my client was able to get something is not normal. The law is such that the stepmother, ex-wife, could have secured everything if we hadn't been really aggressive in litigation, or if we hadn't, we were able to retain an expert witness that helped us, and we had an out-of-court settlement. But things don't always happen that way. So I would advise you to make sure you've made the proper designation. I know that even without a lawyer, you can make sure that your contract beneficiaries are correct by making a phone call, by contacting your financial advisor. But I'm here to answer questions you have, and feel free to ask me anything. You can interrupt me and ask me questions if you want to. I'm happy to answer questions since I'm here. Let's see. So a lot of estate planning is organization. I think the biggest importance of estate planning needs to be done is because, those that we leave behind, a lot of people think, money, it's not going to matter to me after I'm gone. Well, sure, no, it's not. But it's going to matter to the people who are left behind, understand that, they were taken care of according to your wishes, that they received accounts rather than someone that you didn't intend to. Or if you didn't have a will at all, what happens in Texas is it's called intestacy. So you end up passing according to the laws of intestate, which means that the state of Texas essentially creates a will for you and says on your behalf where your property should go. And that all depends on your marital status, how many children you had, who you had children with. Those sorts of matters affect the percentage distribution under intestate law. We don't want to do that. We don't want the state of Texas stepping in and saying, where do we want our property to go? We'd rather just give it to whoever we want to, make sure everything's in line, and I'll tell you, it will save your family a lot of money if you get your affairs lined out before it's needed. I know that estate planners will do very reasonable, conservative, flat fees for putting an essential estate planning package together for you, and that's going to be a lot more reasonable than anyone having to fight, after you're gone. An important thing is to allow your family members to have an opinion in your wishes. I know what recently happened to me is my mother-in-law passed away, and we were talking with her before she was given about three months notice that she was going to be passing away. And so we were talking, she and her sons, and I was part of the conversation, and she was telling us exactly, what she wanted for a memorial service, how she wanted to be celebrated, and then how she wanted her property to pass. And she was able to, in that time, actually execute a will. She hadn't done so before that, and make some inter vivos gifts, which are gifts you can make during life. Little things, family jewelry, things like that. It is a good idea to make them during life if you want to, if you're ready to give them at that time. There are assets that will pass, like I talked about before, pursuant to contract. And then there are also assets that will pass pursuant to a will. So your house, your real property, that's going to always pass pursuant to a will. Or if you die without a will, intestacy laws, which is where the state of Texas creates one for you. Right. So a will, if you're asking me during your life, does it have to be filed? No. What happens is at your death, the person who you've named as executor, they will file that for you in the courthouse. That's one of their jobs. That's right. Yeah. Absolutely. She asked, whether a will needs to be filed with the courthouse or the real property records during life, and the answer is no. And I'll tell you why the answer is no. Is because a will is not effective until a person passes away. It absolutely has no effect during life, and it can be changed at any time. So it would, what happens is upon someone's death, it will be filed with the probate court, at least in Travis County. It all depends what county the person died in or where they had the real property. But in Travis County, it would be filed in the probate court along with the death certificate and along with proper filings, depending on what needed to happen. Texas, very easy, probate-friendly state. It's very simple and very inexpensive to handle probate in Texas. Other states don't have that advantage. Other states, people really are afraid of probate because it can be, thousands of dollars, lots of time. In Texas, it's just not that way. If you've got a valid will that you executed during life, you're talking, one court appearance and I don't know, at least less than $2,000 probably to handle it. It's what I routinely see when there's a valid will in place and there are no questions and no contested litigation. And so it's pretty straightforward in Texas. There are options in Texas called probated muniment of title that people can use, which is, and we've got a question here. Okay, so the question is what constitutes a valid will, and that's a very good question. A valid will in Texas is going to be in writing, and it is going to be signed by the testator. And what lawyers will help you do is make sure that it is self-proving. One thing that self-proving is that you have two witnesses and a notary at the end of the document. That the two witnesses say, I was here, the testator was, of valid mind, of proper age to leave a will, and I witness this, and the notary will sign and stamp that document as well. The self-proving part of the will means that witnesses do not have to be brought into court after someone's death. You want a self-proving will, all competent estate planning lawyers will do that for you so that when someone dies and the will is brought into court, only the executor and the lawyer really need to be there, and that's it. You don't have to have other witnesses come and testify. There is no need for evidence to be brought on. Let me see here. Next slide. So we want to talk about the will. One of the importances in your will is that you choose someone you know and trust to be your executor. Yes, ma'am? Right. So the question is, should the person who wrote the will, the testator, should they make sure during life that the executor has a copy of that will, just so that the executor knows, number one, I've been named as the executor. Number two, who is the lawyer that helped? And we'll talk about those. So I have had clients who were hesitant to provide the executor a copy of the will because they really wanted to maintain privacy. Now, I'll tell you that some people have done that, which is fine. That's up to you to make that decision. But I do always tell the client, if you don't want to provide the executor, a copy of the will, that is fine. What you need to do is let that person know that you are the executor and where they can locate the original will upon your death. That way, you can maintain complete privacy. However, that person can locate the will upon your death. So I highly recommend people keep their wills in a safe deposit box because a copy of a will is a problem in Texas. You really want the original. I'll tell you, if the original is lost, the law presumes that you destroyed the will prior to your death. And you actually have to bring in witnesses into court to say, you know what, actually I know that this person did not destroy their will. Well, how do you know that? I knew that their will was in their bedside table, and I saw the house burn down before anyone was able to run in and get the will out. That sort of evidence. I've handled estates where the will was absolutely lost, and so we did an intestate proceeding and an heirship proceeding to determine who the heirs were. And was representing the heirs who were able to get money because they were not named in the will that was presumably, destroyed. The other side did not have evidence to show why the testator did not destroy that will, and it was their burden of proof, and they weren't able to satisfy that. So those are sorts of things that will happen if everything is not organized. Let me see here. The executor is going to be in charge of managing your estate, managing your finances, making gifts, paying the taxes. There's provisions in the IRS code, so you can have 9 months to say and disclaim a gift, and then there will be no adverse financial implications too. You won't be taxed for that. It'll pass to the next person automatically. So there are reasons you would want to have someone that is timely, organized, will contact a financial planner, CPA, an attorney, something like that, as soon as the person passes away, to keep those affairs in order. So and a point here is make sure it's up to date and valid for your state. Now, I've had many people come into me with a will that was executed maybe in the 80s out of state, which is fine if it was executed several years before, but I look at every will that's brought to me and make sure it's valid today, or was it valid at the time of execution? Because if it was valid then, it'll be recognized in Texas as valid today. But I'll tell you what, that I've had many, many wills brought to me that not only are they not valid today, they were not valid then. And that's a problem, because what ends up happening is then, even though they may have spent the time and money to have a will executed, now it's intestate distribution. And many lawyers will do free initial consultations. So you could bring something into that to them, and they won't charge you at all to look it over and give you an opinion and let you know whether or not you need to do something. So powers of attorney, there are 2 powers of attorney that are routinely exercised. There's a statutory durable power of attorney, so that's for all business decisions. That's also, there's also a medical power of attorney, and those are for medical decisions. There's a point down here, the 3rd point says, it only goes into effect if you are unable to make your decisions. So that means you're incapacitated. Now, that statement is only true as to medical powers of attorney. And I talked about why does that make sense? Because if I can say, I don't want that procedure, I don't want surgery, I want my life prolonged, I should always be able to say that, notwithstanding there being anything in writing. So thinking of that, if you transition in and out of lucid moments, so you're incapacitated one moment, the next you're capacitated, any moment that you are mentally capable of speaking your wishes, your medical power of attorney will not be in effect. You can speak on yourself, but if you go back into being incapacitated, then the power of attorney will step in, and then that person can speak for you. Now, the statutory durable power of attorney for financial decisions, you get a choice in Texas, and you can choose, do I want that effective today when I sign it? Meaning, do I want my husband to be able to go in and sign a contract on my behalf or sell my house for me? Well, you can make that decision for yourself if you trust that person to do that for you. If you do, you can make it effective today. If you don't, you can say, no, I want it only effective upon my incapacity. You can make that decision. A lot of married couples, or a lot of people who are reaching the age where they just don't want to make those decisions for themselves anymore, sign and say, let's make it effective today, fine. A lot of other people say they want it effective only upon their incapacity. I know a lot of men who travel, and they just want it effective today, because if they're not around and they want to sell their house, or they want someone to go into the bank and sign a check for them, fine, they can do that because it's effective today. Advanced directives. So we're also going to talk about the medical power of attorney under this, because it is a type of advanced directive. You may have heard the term living will before. So that's a colloquial term, living will, for a directive to physicians. So a directive to physicians tells your doctors how you want the end of life to look, and that's what you want it to look like. And that's something you do need to think about and communicate to your family members. You're going to make a decision, if I've been diagnosed with an irreversible condition, and no matter what treatment they give me, I only have 6 months to live, do I want to be on life-sustaining support, or do I not want to? You're going to make that election. You're also going to make an election for irreversible conditions and what you want that end-of-life care to look like. You put those in writing, you really distribute it to, I always have my clients distribute it to their physician so that they have a copy on file, because that's really who needs to have one, and also their spouse and one of their fiduciary appointments, usually an adult child or someone like that. So that they can. I'll tell you, this is so important because it takes that burden off of your family. I know when I've had family members that have the living will, the directive disposition in place, it really takes the guilt off of someone who otherwise would have to make that decision, for you. So it's just a really good document to execute, and whoever executes that for you can talk you through what that means and what decisions you want to make on the document. So the letter of instruction, this is the fourth essential document we're talking about. And so this is a personal letter to your estate trustee. Now they're going to be called the trustee for a couple reasons. Did you have a trust? Did you have a testamentary trust? A testamentary trust is a trust that's basically stuck into your will, and then that trust doesn't come into place until you die, until your will is given effect. Or you could have what's called a living will, and a living trust, and that living trust is now effective while you are alive. You could even be the trustee of your own trust if it's a living trust. So you need to make thoughtful consideration to who's your trustee, because that person has, broad and sweeping powers. The executor, same thing. The executor also has lots of powers, lots of authority. That person, another thing to think about as far as who's the executor is how do they deal in family conflict? How good of a communicator are they? Because anytime anyone passes away, family members, we can all understand that because we've all been through losing loved ones. It's a very sensitive, very hard time for everyone. And so we want someone that other people trust as well, because it's just easier on the people that are left if they're not questioning the person that's in authority. If they understand that that person, is trustworthy and is doing what mom or dad wanted to have been done. Another way to avoid the family members questioning that, if you are okay with giving away the privacy, is to distribute a copy of your will, to all of your children, so that they can all then see what you wanted. And then they won't have to question, well, was I given, what I was supposed to in this? I would keep open communication as much as possible. That's just helpful to everyone. So this letter of instruction is going to say, who do you need to notify? What type of arrangements do you want? Any last messages? The slide talks about, do not transfer assets. Okay, why don't we want to do that? Because you don't want to void your will. You don't want to write something that now is taking the place of your will. I had a case where this woman had 5 wills that were all conflicting each other, and they were all in writing, and we weren't even sure if she was mentally capable when any of them were executed, and it was so confusing. The court coordinator told me it was the top 3rd most complicated case that the probate court had ever seen. So it was very frustrating for the family members, to say the least. So you just want to avoid making gifts outside of your will that would give rise to legal problems. Okay, inventory of finances is the last one. This is very important because it'll save your executor a lot of work. The large part of the executor's job is making an inventory of assets, so going through and deciding, what type of accounts did this person have, how much were the accounts, what was the balance, making those distributions. An inventory has to be given to the court when probate is ongoing, and so a judge is going to have to be notified of all of the assets in the accounts. So if you've got a list of what accounts you have, it's not going to really take that burden off of your executor, and it's just going to make sure that nothing falls through the cracks, that there isn't a piece of undistributed property out there that no one knew about. So it's nice to keep a copy of this and keep it centralized. And this is just a question on, do you have any of these documents completed? Yes, we've got a question back here. Let's see here. Right, okay, so let's review this tip. Are you finished with your question? Or? Okay, so the question is regarding this tip at the bottom that reads, don't keep all of your important documents in a bank safe deposit box because they might be closed. That's true. I will say that you want to keep the original and something like that if you have one, and then distribute copies if you can. Distribute a copy to your spouse, a copy to anybody else who's a fiduciary appointment. However, if you have told the executor that that person is the named executor in your will, the bank, if someone passes away, if I were to take a death certificate up to the bank and say, I don't have a key, I don't have proof of this, but if you look in that safe deposit box, I'm the named executor, they will allow that box to be opened with the death certificate to make that determination. So if nothing else, if there is no copy, with a death certificate, you can get permission by a bank to get that opened up. Now, you'll only be able to get the documents if you truly are named the executor. That's the key there. So we talked about the difference between, well, we talked about a trustee and what a trustee does. Now let's talk about a beneficiary. So a beneficiary, that's a term, that's a contract term. So that means that the person is named in a writing, not a will, because wills in Texas are called devisees or legatees, depending on whether you are given real property or personal property. So personal property is anything that's not land or real estate. But a beneficiary is someone who maybe is named on your life insurance. And this is getting your beneficiaries right is the easiest and basically free if you can do it on your own, to call your benefit plans person to make sure you have it right. The easiest way to get your estate planning in order right away. These assets will pass without any court proceedings at all. When I meet with clients, I always talk to them through all of their contracts that they have, that they can make sure are named to the right person, because the beneficiary doesn't have to wait on anything except a death certificate to get paid on that contract. So I'm sure everyone here has a checking account. There's going to be a beneficiary named on that checking account who receives that money upon your death. If your lawyer advises you to name a beneficiary rather than naming your estate, that is advisable. It would be dependent on your circumstances, but if you can name beneficiaries rather than your estate, you don't have to wait on any type of court proceeding for that person to get paid. Now, I'll tell you, I have had some clients where it was more appropriate to name the estate. And what that means is that whoever's named in your will, they get that money that's on the contract. I have had some people name their estate, and that's because they have minor children and because they put in a testamentary trust in the will for the minor children, and they wanted that testamentary trust that was only given effect upon their death. They wanted that to govern the money, so they named their estate so that it would flow through the will and then flow through the trust. It all depends. More often than not, it's appropriate to name a beneficiary on your contract, and then it would simply pass to the person with the presentation of a death certificate to the holding institution. So the importance of being prepared. You'll be organized. The people who you want to give the gifts to will get the gifts. And, something as easy as, you might think, well, I've only had one marriage, I don't have any stepchildren, I have a very simple family order, nothing will be questionable. I've had families like that even that there have been problems with. Yeah, I've had families that there was one wife, 2 daughters of the same mother and father, no will. Now, there were actually problems in that situation, whether it's fighting or whether it's where does the house go, because we have to look at what the law says where the house goes. But then even real estate companies, if the house needs to be sold, they will require the children, for example, to fill out warranty deeds, back to the husband because the real estate company doesn't want to get brought into court, even if it's a losing battle at the end for the real estate company. So you end up creating a problem when things are not in order. And I'm sure I will see many more problems that I haven't encountered before, but I feel like to date I have seen more than I would have anticipated seeing at this point. Let's see here. Your estate will be taken care of by the person you choose, so your executor or your trustee, depending on what you put in your will, and then family discord can be avoided. Lastly, we are open for questions if you have any questions. And we'll take the woman in the back and in the rear. Mm-hmm. Okay, I'll tell you that I'll have you repeat the whole thing, because what I heard so far is if you're named power of an attorney, on it to do financial affairs, and if you're already named executor on the will, something about what happens when the person dies. So. Okay, and then can you tell me how your question, what is the significance of the fact that the person had the power of attorney during life and was named the executor? Is that? Mhm. Mhm. I see. Okay, so the question is, and it's coming from a personal example that she had out of state, where she was named power of attorney on a bank account, also named executor of the will, and then there was a significant turnaround time between being able to act pursuant to the power of attorney or pursuant to the powers of executor, letters testamentary in Texas. I'll tell you that is all dependent in Texas on who was named as the beneficiary, and I'll tell you why. Because if you are named power of attorney under the statutory durable power of attorney on your spouse's account, well, you can go in and basically deplete the account if you wanted to. Now, if your spouse then died and now you're named executor under his will, I'll tell you that it depends on who was the beneficiary, because if there was if you or your child or anyone, if Sarah Smith was named beneficiary of that contract, Sarah Smith produces a death certificate to the bank and the money will get sent to her. If in Texas the beneficiary was my estate, well then you're going to have to wait until you get your will, your death certificate, and your application to probate the will all submitted and filed into court, and there's a hearing, and the judge issues a court order with letters testamentary to you as executor. Then you go back to the bank and you say, I'm the executor, I've been authorized to make this distribution, and you just make it then to whoever the will says. So it just depends on who's named as the beneficiary that way. And that goes back to the fact that it might be easier to name someone as beneficiary rather than your estate, because you don't have to wait on the court system. And then this woman here in black had a question. Mm-hmm. Okay, right. So that's a good question. The question was, do I recommend LegalZoom? And me personally, I would say no. And you guys are welcome to use, obviously anyone you want. I'm not here promoting my law firm by any means. I'm here giving information. I'll tell you no, because I have had as early as last week, when I was still on maternity leave, people calling me about problems they had had or needing their LegalZoom documents reviewed. And then one of my mentors, that I meet with on a regular basis, says that's her largest source of clients is actually LegalZoom. So whatever that means, you can take that for what it's worth. But that's been my experience. I've had several people bring in documents that were executed from LegalZoom, And they were about 90% accurate. I found them to be about 90% accurate, but the problem was that 10%, the 10% problem, and those documents basically rendered it needed to be redone. And that can be a frustrating conversation for the client who think, I don't know how much it costs us to have documents drafted on there, but it's frustrating because it does cost something. And then are there any other questions? Okay. Mm-hmm. Right. So the question is, she's named power of attorney and executor in her parents' documents. Power of attorney, as you know, that's only going to be effective while they're alive. Do you anticipate a problem while they're alive? Okay. Well, upon your parents' death, it's a sensitive time for siblings. So the only thing I have seen that really helps with that is open communication. I know that just sounds, oh, okay, fine, it's easy to say, but it really does help when it comes from the parents and not from you. I recommend the person who wrote the will to communicate to the other siblings who they have named as executor and not keep it a secret until the time comes, because it's just, when you have things that are secretive, if you can have open communication, a lot of times you can't tell people, but if you can easily have a conversation with other people who might be expecting to take from your estate, if you can explain to them what's in your will, or who's going to be in charge of that, it just makes it easier. It makes them feel like there aren't secrets, because secrets always make people feel uncomfortable, especially when it comes to death and finances and even a little bit amount of money. I've seen a little bit of amount of money cause big problems. So, all right, any more questions? Or is that that? Okay, well, thank you for your time. I really appreciate it.